Hello everyone, my name is Daisy Chen, and I am a paralegal at Oakland Solicitors. Today, I'm excited to guide you through the key concepts of FOB contracts, a cornerstone in international trade law. In my presentation, I will include 1. What FOB contracts are. 2. How risk transfer in these contracts. 3. The responsibility of both buyer and the seller. 4. What the remedies are available for breaches, which example for case law and legislation. Let me start with the question. What are FOB contracts? FOB, or Free on Board, is a common international trading agreement. Under this contract, the seller must ensure the goods are delivered to a specified port and loaded onto a shipping vessel. Once loaded, risk and ownership transfer to the buyer. The legal framework for FOB contracts is established by the Seller of Goods Act 1979, SOGA, and international trading rules such as Incoterms 2020, SEC rules. Let's move to risk transfer. 1. Defining future of FOB contracts is how risk transfer. General rule, the risk passes to the buyer once the goods cross the ship's rail. Exceptions, later vessel nomination by the buyer can delay risk transfer and give the rise to seller remedies. Next is key case studies. Let's solidify this principle with the 2 landmark cases. 1. Perry Company sued Sandia Steam Navigation Company, 1954. The court defended that the FOB contracts risk transfer when the goods cross the ship's rail, even if disputes rails with the carrier. This establishes the importance of risk timing in such agreements. Here is another case. Bunch Corporation sued Tree Tax Export SA, 1981. The buyer delayed nominating a vessel, breaching the contract. The seller was awarded damages. This case highlights buyers' obligation to fulfill their duties, promoted avoid liability. Let's move to duties of parties. FOB contract clearly outline the responsibility of both seller and the buyer. The seller's duty. Under a classical FOB contract, we can see 5 main obligations. 1. Ship the goods as a specific in the contract. The seller must be ensured the goods match the description in contract. 2. The seller is responsible to all costs up to the port, including handling and transportation. 3. The seller must be ensured goods are shipped on time at the port of the shipment. 4. The seller also must notify the buyer of the shipment in a timely manner, enabling the buyer to arrange insurance. 5. In most cases, obtain an export license. Under a classical FOB contract, the buyer also has two key responsibilities. First, the buyer should secure shipping space by arranging and communicating vital details to the seller in time. Second, the buyer should make a payment for the goods, which is typically due once the goods pass the shipper's rail. Now move to remedies available. Seller's remedies under a classical FOB contract. If the buyer breaches the contract, the seller has the right to take action for the price. If the property in the goods has passed to the buyer, but payment has not been made. Secondly, damages for non-acceptance. The seller may claim damages if the buyer wrongfully refuses to accept the goods. Another remedies include the right to a lien on the goods until payment, stoppage in the transit, and the right of resale, particularly if the buyer becomes insolvent. However, let's move to buyer's remedies under a classical FOB contract. If the seller breaches the contract, the buyer may 1. Reject the goods when the seller has not title to the goods, or the goods do not match the contract description or quality. 2. The buyer may claim the damages for defective goods or non-delivery. 3. Sue for non-performance if the seller fails to fulfill their obligations. However, there are limits on rejection. The buyer cannot reject the goods if the breach is so minor that it would be unreasonable to do so. To sum up, FOB contracts are widely adopted due to their clearly rules for risk transfer, balanced responsibility for both seller and the buyer, and effective remedies for breaches. They also enhance the trust, reduce uncertainties, and promote efficiency in global trading. By understanding those principles and learning from case studies, businesses can safeguard their interests and ensure smooth global transactions. Thank you for your attention, and if you have any questions, I would be happy to answer them.